in making a case regarding impeachment. Let us begin with what should be uncontroversial. The Constitution sets out explicit criteria for impeaching and removing the President, Vice President, and all civil officers of the United States. These criteria, as articulated in Article 2, Section 4, are the following: treason, bribery, or other high crimes and misdemeanors. Only one of those crimes, treason, is defined in the Constitution. It shall consist only in levying war against the United States or in adhering to their enemies, giving them aid and comfort. The critical words levying, war, adhering, enemies, aid, and comfort are not further defined. 3 procedural prerequisites for conviction of treason are enumerated. 1. The testimony of 2 witnesses. 2. To the same overt act. 3. Or a confession in open court. The other specifically enumerated crime, bribery, is not defined in the Constitution, but Article 1, Section 9 provides that no federal official shall, without the consent of the Congress, accept any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. And Article 2, Section 1 precludes the President from receiving other emoluments from the United States or any of them. Violation of these provisions are not explicitly made a crime or a ground for impeachment. Under the common law at the time of the Constitution, merely giving or accepting something of value did not constitute the crime of bribery unless it was specifically intended to influence a public official's action. So it is unclear whether the word bribery, as used in the constitutional criteria for impeachment and removal, incorporates the emoluments clause or is limited to the crime of bribery as defined at the time of the Constitution or by subsequent statutory enactments. The remaining criteria for impeachment, other crimes and misdemeanors, are not defined, nor are procedural requirements for conviction of these crimes set out, except insofar as the Constitution and the Bill of Rights establish procedural requirements for conviction of all crimes in the courts of law. The Constitution is not explicit as to whether the procedural requirements for conviction of treason apply only to criminal trials in courts of law or as to trials in the Senate for impeachment. Nor is it clear from the text of the Constitution whether the general procedural protection in criminal trials for bribery or other high crimes and misdemeanors are required for an impeachment trial based on those crimes in the Senate. These general procedural protections include the privilege against self-incrimination contained in the Fifth Amendment and the right to be confronted with the witnesses against him, as required by the Sixth Amendment. It is clear that other procedural safeguards, such as indictment by grand jury and trial by petty jury, are not applicable to impeachment since the Constitution provides that impeachment, which is the counterpart of indictment, is by the House of Representatives, and the trial is by the members of the Senate. Article 3, Section 3 explicitly states that the trial of all crimes except in cases of impeachment shall be by jury. The procedures for impeaching and trying a president are incompletely articulated in the Constitution. Remarkably, the text says nothing at all about the procedures for impeachment by the House. It does not even tell us whether impeachment requires a simple majority of House members or the kind of supermajority, 2/3, required for removal by the Senate. By implication and precedent, a bare majority can impeach. The substantive criteria for impeachment are the same as for removal: treason, bribery, or other high crimes and misdemeanors, but the standards for establishing these criteria are not set out in the Constitution, nor is it set out whether standards for impeachment are the same as for removal. If impeachment by the House and conviction by the Senate were to be analogized to indictment by a grand jury and conviction by a trial judge or a petty jury, the standards would be significantly different: probable cause for impeachment and beyond a reasonable doubt for conviction. But it isn't clear whether this analogy is apt. Nor is it clear whether the subject of the impeachment, the president or other official, has any procedural rights in the House. May he or his lawyer cross-examine adverse witnesses? May he testify?